action. What is the procedure? Once the complaint is received by the IBBI, they appoint investigating authority. Then a notice is issued by the investigating authority on which reply is to be given by the insolvency professional. So this notice is issued by the investigating authority, and then the written submission is to be done by the insolvency professional, and that is also time bound. You have to reply within 15 days or so. So again, on the basis of your reply or the submission, the investigating authority prepares a report which is known as investigation report, and this report is finally submitted to the IBBI. So this report basically speaks out or tells what all contravention you have done, or what is your take on that, or what is your submission on that, and what is the ultimate conclusion according to the investigating authority. So on the basis of that, investigation report, which is given to the IBBI by this investigating authority, IBBI may or may not issue the show cause notice to the insolvency professional. So if they consider, according to this investigation report, that the insolvency professional has not complied with certain provisions, or he or she has contravened the law, then IBBI is empowered enough to issue this show cause notice. So this, based on the material available on record, including the investigating report, the show cause notice is issued. Now, what is Regulation 3? We, as just now discussed, that the power is with the IBBI to, start the investigation proceedings. So what is contained in this Regulation 3? So filing of grievance and complaint is the heading for this regulation. A stakeholder who wishes to file a grievance shall file it with the board. So generally, whosoever wants to file any kind of complaint, what is the authority, what is the relevant authority? It is the IBBI. So any of the stakeholder, be it operational creditor, financial creditor, or the directors or anyone, they can file in this grievance or the complaint to the board, IBBI. So what should it contain? What should this grievance contain, or what documents it should have along with it, or the attachments, as we can say? So a grievance shall state details of identity of the aggrieved, details of the identity of the service provider, details of the conduct of the service provider that has caused the suffering to the aggrieved, details of suffering whether pecuniary or otherwise the aggrieved has undergone, how the conduct of the service provider has caused the suffering of the aggrieved, the details of his effort to get the grievance redressed from the service provider, and why the response, if any, of the service provider is not satisfactory, and how the grievance may be redressed. So it is a detailed, a complaint along with the final conclusion or how this can be resolved. So everything from starting to end, this this stakeholder has to express in his complaint to establish the fact that really this insolvency professional is not doing the things according to the law. A stakeholder who wishes to file complaint shall file it with the board in Form A. So this is the format wherein the complaint is filed, along with a demand draft of 2,500 rupees drawn in favor of the Insolvency and Bankruptcy Board of India, payable at New Delhi, or on online acknowledgement of 2,500 rupees paid to the credit of the board towards the fees. So this whole complaint should be in a particular format, which is Form A. It can be filed by any of the stakeholder, as we have just understood, along with a fee of 2,500 rupees. It can be paid online, or you can prepare a DD for that. A grievance or complaint, as the case may be, shall be filed within 45 days of the occurrence of the cause of action for the grievance or the complaint. So this point is very, very important for all of us. If this time limit is crossed, you can simply mention it that it has crossed the time period of 45 days, and therefore we are not liable to answer or do anything. So if any stakeholder wants to file a complaint, there is a time limit for it. Within 45 days of that cause of action or the grievance, he has to file a complaint, or otherwise this will not be, otherwise we can say this will become time barred. Provided that the grievance or complaint may be filed after the aforesaid period if there is a sufficient reason justifying delay, but such period shall not exceed 30 days. So an extension of 30 days is also allowed here, but again, sufficient reason has to be justified. A grievance or a complaint shall be filed with the board on its dedicated portal. The website here it is given. So this has to be submitted online. So this is the complete procedure how this complaint is filed and within which time period the complaint shall be filed. So as we all know that ignorance of law is no excuse, and therefore we can simply say that being an insolvency professional, how many laws will we keep in mind, or how many things we will take care of. We cannot say like that, because if you are an insolvency professional, you have to abide by law. You have to take care of all the rules and regulations, and wherever you are not fulfilling the code of conduct, you will be held guilty, and of course you will be punished. And as we all know, what kind of punishments can be there? Maybe your this registration can be cancelled, or you may be penalized with some financial or the monetary punishment can be there, or maybe sometimes it is like for 1 year or 2 year you may not be allowed to work. And it is a very simple thing to understand that once a show cause notice is issued, you are not allowed to continue with your assignments, and that is the very difficult thing on the part of insolvency professional. Though this has been highlighted many times, but as of now there is no law in favor of insolvency professional to continue with his work until unless he is proven guilty. Still he is not allowed to work. So we are discussing first case law for the day in the matter of Miss Maya Gupta, insolvency professional. And this is a recent judgment. It was pronounced on 5th February 2024. Let us discuss the facts of the case. The Honorable NCLT, New Delhi, Principal Bench, that is the adjudicating authority here, by order dated 23 March 2022, admitted the application under Section 7 of the IBC 2016, filed by the State Bank of India for initiating the CIRP against Messrs. Action Ispat and Power Private Limited. So till here, I think you have all understood that this corporate debtor, that is Action Ispat and Power Private Limited, which is a private limited company, a CIRP application was filed against this by State Bank of India, who is obviously the financial creditor, and it has filed an application under Section 7, and which was admitted by the NCLT on this particular date, 23/3/2022. And here only Ms. Maya Gupta was appointed as interim resolution professional. So this is the background. Who is the corporate debtor? Who is the financial creditor? And this Maya Gupta ma'am is the interim resolution professional here. So the procedure, this was the starting point, that the CIRP proceedings started on this particular date. However, meanwhile, complaint was received by IBBI, and then the IBBI complaint against obviously the insolvency professional, Ms. Maya Gupta, was received by IBBI. Then the appointed investigating authority, and then the notice was issued by the investigating authority asking for the written submissions from the insolvency professional. So the insolvency professional made a reply. I have not put the dates just for the sake of being crisp, short and crisp. So this is the whole procedure. The appointment of the authority is there, then the issue notice, and then the reply is submitted by the insolvency professional. Written submissions are made, and then on the basis of those submissions, the investigation report is prepared by this investigating authority, and it is submitted to the IBBI. In this case, normally, besides the written submissions, personal hearing is also there. So an opportunity of being heard is also given to the insolvency professional. That opportunity you must all seek to explain yourselves better if any this kind of situation happens ever. Based on the material available on record, including the investigation report, the show cause notice was issued on 20th February 2023. So as you can see, after it's around 11 months from the CIRP proceedings, this interim resolution professional, that is Ms. Maya Gupta, received a show cause notice uh, saying that there was some kind of contravention made by her. So what was the exact contravention? We'll discuss in detail in the later slides. Okay, so it was observed that Ms. Maya Gupta conducted the first meeting of the Committee of Creditors on 3rd May 2022, wherein various agendas pertaining to CIRP process were discussed. As we all know, COC meetings are to be conducted, and she also conducted a COC meeting on this particular date, wherein all the relevant agendas were discussed. Later, CFM ARC, which is one of the financial creditor, having 59.11% of voting rights, via its email dated 22nd May 2022, requested Ms. Maya Gupta to conduct the COC meeting with one of the agenda for replacement of IRP. However, despite that, Ms. Maya Gupta delayed conducting the COC meeting. So I'm just explaining this second paragraph in short for you. What happened was, in this first COC meeting, they put up the agenda, and there itself they decided that uh, they can conduct meeting on a shorter notice also, and that was approved by the majority of the creditors. So that was resolved. So one of the financial creditors, CFM ARC, who was having 59.11% of voting rights, they requested Ms. Maya Gupta, that is the insolvency professional, to conduct a shorter meeting on a shorter notice. There the agenda was to replace Ms. Maya Gupta herself. However, Ms. Maya Gupta did not give more attention to that. She simply delayed, kept on delaying, saying that we cannot conduct this kind of meeting on a shorter notice or something like that. She kept on delaying conducting the COC meeting. What is the relevant provision according to this concept? So as per regulation 18.3 of the CIRP regulation, it is mandatory on the part of IRP to conduct COC meeting and place any proposal received before COC if the same is made by the members of the committee having at least 33% of the voting rights. So this is the relevant provision we must all be aware of, that if any of the financial creditor is asking you to conduct a meeting, it is giving any agenda to conduct a meeting, and the voting percentage of that particular person or the creditor is at least 33%, then it is your duty, it is the duty of the insolvency professional to conduct the meeting. Otherwise, it will be a contravention of this regulation 18.3. So that is why, since here we can see that the CFM ARC was holding 59.11 percentage of voting rights, which is obviously more than 33% as required by the law. It was mandatory for Ms. Maya Gupta to conduct the meeting, but she kept on delaying that. In view of the above, the board held the prima facie view that Ms. Maya Gupta contravened section 2082A and 208(2)(e) of the code. Also, the regulation 18.3 of the CIRP regulation, 72A and 72H of the IP regulations read with clause 1, 2, 3, and 14 of the Code of Conduct as specified in the first schedule of the IP regulations. So if just a meeting is not conducting, if you are not conducting a meeting in time, um, on the request of any of the financial creditors who are holding this at least 33% of voting rights, then in that case, you are contravening so many provisions. You are contravening the sections of the code, you are contravening the code of conduct, then you are again contravening this regulation 18.3, which is clearly saying that you have to conduct a meeting if it is requested by any financial creditor who's holding this at least 33% of the voting rights. So this is the fact of the case, that Ms. Maya kept on, delaying conducting the meeting even after being asked by the financial creditor. So what is the basic issue? I think you all have got the issue. Is it mandatory on the part of IRP to conduct the COC meeting and place any proposal received before the COC if the same is made by the members of the committee having at least 33% of the voting rights? Obviously, it is mandatory because it is given in the regulation. She has to uh, forcefully conduct the meeting. That is the thing. So what was the observation of the disciplinary committee in this regard? In the first COC meeting, Ms. Gupta had agreed to convene the meetings at a shorter notice. She did not conduct the second COC meeting at a shorter notice in spite of repeated requests made by the same by CFM ARC by email dated 22nd May, then again on 26th May, then again on 4th June. So 3 times the request was made by this financial creditor, and this was not done by the insolvency professional. The second COC meeting was finally conducted on 18th June 2022, and after some deliberation due to some technical issue in the virtual conference, the meeting was adjourned to 1st July 2022. So this meeting was conducted, but again this was adjourned to some other date. And the agenda, as we know that the agenda which was asked by that particular financial creditor was to replace the insolvency professional. In the adjourned second COC meeting, the agenda for the confirmation of IRP as RP could not be confirmed as two COC members having collective voting share of 55.75% did not vote. So this thing could not materialize, or this confirmation, or the this was obviously, it was in favor of Ms. Maya Gupta that she was not replaced because the voting was not done as required. The third COC was adjourned on the request of some COC members, and ultimately in the fourth COC meeting held on 22nd July 2022, the proposal of confirming IRP as RP was rejected. Thereafter, an application was filed before the adjudicating authority for replacement of IRP. During pendency of this application for replacement, in the 7th COC meeting held on 14th November 2022, resolution was passed for appointing Ms. Maya Gupta as the resolution professional and for withdrawing application filed before the adjudicating authority for replacement of Ms. Maya Gupta. This resolution was also voted in favor of Ms. Maya Gupta by CFM ARC. So why we are highlighting this? Because earlier this CFM ARC financial creditor wanted to replace Ms. Maya Gupta. However, as the time lapsed, he was also convinced, or they were also convinced, that Ms. Maya Gupta should stay there as the professional, insolvency professional, to continue the proceedings. So they also voted in favor of Ms. Maya Gupta, who had filed the complaint before the IBBI. The DC further notes that the resolution plan for the corporate debtor was approved by the COC on 27 December 2022, and the same was also approved by the adjudicating authority on 26 September 2023. In view of the aforesaid, though the disciplinary committee accepts the submission of Ms. Maya Gupta, however, the fact that Ms. Gupta did not call COC meeting as requested by the CFM ARC, holding 59.11% of the voting share, cannot be ignored, which is a violation of the regulation 18.3 of the CIRP regulation. So as we can see, disciplinary committee is monitoring everything. They are seeing that, okay, though the meeting was conducted, she was confirmed to act as a resolution professional and continue, but still this cannot be ignored. The request which was made by the financial creditor and which was ignored earlier by Maya Gupta, this cannot be taken lightly. So some or the other action should be taken. This is what was the view of disciplinary committee. So what was the final order or the judgment? DC finds that Ms. Maya Gupta had contravened Regulation 18.3 of the CIRP regulations. However, considering the fact that COC had subsequently passed resolution to withdraw the application filed before the adjudicating authority for her replacement and confirmed her as RP, the DC takes a lenient view. So a lenient view was taken by the DC, though she had made a contravention, but still a lenient view was taken. The DC warned Ms. Maya Gupta to be extremely careful while handling assignments under the code and ensure full compliance with the provisions of the code and regulations made thereunder. So she was relieved, but this may not happen with others. I mean, it was her luck, it was her good luck that a lenient view was taken and she was, not compelled to pay any penalty or anything like that, or um, she was not made to surrender her registration or anything like that. But this might not happen with any of us. It is not certain. So what we must all understand that whenever a request is made by any of the financial creditor, and if the percentage of voting rights of that particular financial creditor is at least 33%, we are bound to call the meeting. We are bound to call the COC meeting. Anyone has any idea how many COC meetings should be conducted? Now, recently a circular has been passed with respect to that. How often this COC meeting should be conducted? Anybody having any idea so that we can keep the session lively?
Once every month.
Once in every month, yes, sir. And there is also mentioned that the time gap between two meetings, something is related to that also.
Maximum gap should be of 3 months.
Right, sir. So this is why this kind of regulation has come up. Any idea regarding that also? Why is it compulsory to have meetings in such a short span of time again and again? Monthly meetings, because it will be very hectic for all of us to, keep a track of all the corporate debtors that they are having their regular COC meetings. Because again, minutes have to be prepared. Obviously, the notice of the meeting is to be circulated well before the time. So why this has happened? Any idea? Sandeep sir, you can say something as per your experience.
Ma'am, sorry, I beg your pardon. Can you repeat the question?
Sir,
Why is the frequency of COC meetings?
Yes.
Okay, that you are saying.
Yeah.
So why the frequency is more? That is what you said?
Yes, sir. Now it has been fixed for 1 month. I mean, every month a meeting should be conducted with COC.
Okay. I'm sorry. Basically, I'm doing voluntary winding ups, maximum 10, 15 or 12 voluntary winding ups I'm doing right now. But still, if, I can apply the logic which is
Yes.
there. Of course, IBC is a time-bound process. So, as a what we call as on fast track basis, we should be able to obtain the decision of COC within time bound manner. The process should be able to complete it. So, for that purpose, maybe the frequency is more for conducting the meetings.
There was a special circular also with respect to this, so that is what I'm looking for. Anyone else who can speak up? Rajesh sir, because I can see you. I can ask. You're on mute, sir, I guess. We still cannot hear you, sir. Actually, what my purpose was to keep you all engaged, because it is not just the name of the case. It is not relevant that we should know the case name or things like that. We should understand why these kind of things are happening, why disciplinary committee is, keeping track of IPs again and again, and what faults we are basically doing. So it might happen that, we are so busy in our engagements or in our assignments, we just don't keep a track of this COC meeting. So recently a circular has been passed that every month this COC meeting should be conducted. Yes, Rajesh sir, can you speak up now? Not audible, sir. Okay, sir, we'll catch you in a short time. Till then, you can just adjust your things. see, nowadays one more thing which was there recently passed through a circular that you have to get approved the CIRP cost from this in every COC meetings. So for that reason, you have to conduct meetings frequently just to make the things readily available for the COC to approve. And it should not be anything actually. It should not be there. Should not be any time gap, or the approval should be very fast. So that is why this COC meetings are being conducted in a regular way. That is monthly if you can conduct, and in that meeting itself you can pass an agenda that you may pass a motion that we can, if you all agree, we can pass it, we can conduct a meeting maybe once in 2 months or once in 3 months, but it should not be more than that. But as per the law, it is mandatory to conduct a meeting monthly. But if there is a proviso also in that if the members agree that they can, the maximum time gap could be 3 months. So that way you can proceed. But the thing is, the CIRP cost is now to be approved by the COC. So timely you have to prepare the documents, you have to keep your accounts ready, and you should present it before them so that everything gets approved timely. So that is the main thing. And this kind of thing you must understand, that it is not just that the meetings are conducted as and when only when IP is free. It is not like that. If someone is requesting you to conduct the meeting, then also you should take care that whether we are bound to conduct such kind of meetings or not. So this is one provision which you all must understand. And the regulation which was mentioned was 18.3, wherein it is clearly said, ma'am found the press release. Yeah, exactly, sir. Yes, sir. So it was there in that particular case. So I'm proceeding to the next case. Just I'm sharing the screen again. So we are done till this first case. This is the second case. This is again a case by the disciplinary committee. So this order was pronounced by them. So it is in the matter of Mr. Alok Kumar Kuchal, that is an insolvency professional. This is again a recent judgment, 16 February 2024. Let us discuss the facts of the case. The Honorable NCLT Allahabad Bench, by order dated 16th April 2019, admitted the application filed under Section 7 of the Code for initiating CIRP of Ratandeep Infrastructure Private Limited. So in this first paragraph, it is just stated that Section 7 application was admitted against this corporate debtor. The name of the corporate debtor is Ratandeep Infrastructure Private Limited. And this was admitted by NCLT Allahabad Bench. Sorry. Mr. Alok Kumar was appointed as the interim resolution professional on the same day and was later confirmed as a resolution professional by adjudicating authority on 11 June 2020. So, okay, this is also a simple para to understand. Let's move further. Since COC did not find any possible way of resolving corporate debtor, it recommended for liquidation with 100% voting share, and the liquidation of corporate debtor was approved by adjudicating authority on 31st January 2022, and Mr. Alok was appointed as the liquidator. So in this third para, we can easily understand that since they were not getting any resolution applicants for the purpose of resolving the corporate debtor, they had to go for this liquidation. So again, the liquidator was the same person. Mr. Alok Kumar was appointed as the liquidator. Continuing further. So during the liquidation proceedings, a complaint was received by IBBI. Then they appointed the investigating authority. Then the notice was issued by the investigating authority asking Mr. Alok to reply on that. Then a written submission was given by the insolvency professional, that is Mr. Alok. And based on that, the investigation report was prepared and it was submitted to the IBBI. Now, IBBI finally issued a show cause notice based on the material and the investigation report. And this show cause notice was issued to Mr. Alok on 13th October 2023. The show cause notice alleged contravention of provision of the code and its underlying regulations. Mr. Alok Kumar replied to the show cause notice via email dated 25th October 2023 and also availed the virtual personal hearing opportunity. Now, what was the contravention? Mr. Alok was appointed as director in Tirupati Balaji Fibers Private Limited and Silver Tone Papers Limited during the currency of the CIRP of the corporate debtor. So, is there any contravention while a person, the insolvency professional, can be if he is appointed as a director in any company? Is it some kind of contravention? What do you say? You people have to say something. Appointment as a director, whether insolvency professional is allowed to act as a director in companies.
Yeah, there is a contravention if the companies are related.
Of course, that is the key thing. That is the key point here. If these companies are related anyhow, then this Alok Kumar is doing some kind of contravention. But again, sir, one more thing we should be aware of. If there is some related party and if you are related to someone, then a disclosure has to be made. So if you are giving the disclosure disclaimer that yes, I'm related to this person, maybe some relaxation can be given in this regard. But if you are not disclosing at all, that means you are hiding the fact, then of course you are doing contravention. One of the shareholders of the corporate debtor. So here in the next paragraphs, we will understand that how these were related. And therefore, this Alok Kumar was being appointed as a director in a related company of the corporate debtor. So thereby there was a contravention. One of the shareholders of the corporate debtor, Mr. Prasoon Agarwal, holding 10% share in the corporate debtor, was also one of the directors in Silver Tone Papers Limited, wherein Mr. Alok Kumar has been appointed as one of the directors after initiation of CIRP. Therefore, his action of accepting directorship of a company wherein a shareholder having substantial shareholding of the corporate debtor is also a director is against the code of conduct for the insolvency professional. So it is clearly mentioned in code of conduct that you cannot be a director of a related party of the corporate debtor. The show cause notice herein alleges contravention of the code of conduct for accepting directorship of Silver Tone Papers Limited during CIRP of the corporate debtor. Mr. Prasoon Agarwal, that is the complainant here, and son of Mr. Surendra Agarwal, was holding 10% shareholding in the corporate debtor and was one of the directors of Silver Tone Papers Limited. Also, Mr. Surendra Agarwal, that is the father of the complainant, was one of the directors of the corporate debtor and held 5.79% shareholding in Silver Tone Papers Limited. So the companies were clearly interrelated. So this is all the fact that finally we can say that the companies were related and therefore this person would be interested party. If he has become the director of those companies, then he will become the interested party. Then the RP is supposed to file application under section 66 against the directors in the case of wrongful trading. This is what the view of the DC here is that if suppose there is some kind of wrongful trading or some willful default is there in case of the corporate debtor, then he must file a section 66 against the directors. The same gets seriously compromised once he accepts the position in a company where such interrelation exists. So if he himself becomes an interested party, he will lose his independence and he will not pay proper attention to what is required as per law. And therefore, he might not file an application in case of any wrongful trading of the corporate debtor or these companies, if this kind of interrelationship exists. Section 2082A and E of the Code, Regulation 72A and H of the IBBI Insolvency Professional Regulations 2016, that is the IP regulations, read with clause 1, 2, 3, and 5 of the Code of Conduct specified thereunder. So the independence part is the issue which is raised here. whether independence of insolvency professional is compromised once he becomes one of the directors and sits on the same table with the interrelated directors on the board of the directors of another company. So I think this case is very well understood. It is just related to the independence of a person, because every professional, be it CS or CA or insolvency professional, the code of conduct clearly says that you have to be independent of the person. You cannot be related to the person whose work you are doing. So if you are not independent, you will not be able to clearly comply with the rules and regulations, or you might skip a few things where your interest is involved. So thereby it is again and again saying that independence here in this particular case where the companies are interrelated is compromised. So this was the issue basically. What was the observation? There is no allegation of conduct unbecoming of an IP by way of compromising his independence, which has been made in the show cause notice. The Honorable NCLAT did not. So this thing, okay, this NCLAT part, I have to tell you because I have taken it in short. Normally, submission which the insolvency professional has given, he has mentioned in his submission that there was no this kind of contravention was not pointed out by the NCLAT. They have approved the liquidation proceedings. They have approved they know each and everything about the proceedings of the corporate debtor, but they have not pointed out anything. Then why these allegations are made for me in this regard? So if NCLAT has given me clean chit and they have allowed me to continue as a liquidator, why now these allegations are there? That is what his view was. But what DC is saying, let us examine that. DC is saying that NCLAT was just looking on the proceedings of the corporate debtor. They were not identifying, or they were not questioning about the independence of the particular insolvency professional. So they have missed that point. They could not, they did not give any. They did not say anything about the position of the insolvency professional. So thereby, it is not that if if the corporate debtor has been given is allowed to go into the liquidation proceedings, there cannot be said that this liquidator is independent. There can be a case where NCLAT has missed that particular point, because NCLAT is only concerned, it is only taking care whether the CD should go into the liquidation or it should do otherwise. So NCLAT has just pointed out that part. It has not commented anything regarding to the independence of the insolvency professional, and therefore that particular submission was totally denied. I'm reading it again for the benefit of all. There is no allegation. This IP is saying that there is no allegation on the conduct of unbecoming of an IP by way of compromising his independence, which has been made in the show cause notice. The Honorable NCLT and the Honorable NCLAT did not have any occasion to examine the same, because they did not examine it. Hence, it is not correct on the part of the liquidator to state that same matter has been dealt by the Honorable NCLAT, and hence it is not covered by the principle of res judicata. This principle of res judicata simply says that if anything is taken up by one court, the same thing cannot be taken up by the another court. So same kind of thing cannot be, same proceedings cannot take place at two places. So if they are not handling that particular thing, then only the other court is allowed to take up that matter. Hence, the statement of the liquidator in this regard is misleading. Accepting post, this para is very, very important. Accepting post of director in a company where director is a shareholder of the corporate debtor and shareholder in the company is a director of the corporate debtor is amounting to a situation where IP cannot be said to have complete independence in its professional relationship in terms of clause 5 of the code of conduct. So this clause 5 of code of conduct clearly mentions when there is a breach in the independence. The fact that Mr. Alok Kumar resigned from the post of the director after 6 months So this is again one of the facts which we have not taken it earlier, that though he was a director for some time, for 6 months he was a director, then he resigned from the post so as to avoid all these confusions. So he's clearly the here the DC is saying that the fact that you have resigned from the post of director clearly states that you also felt somewhere that this is a kind of contravention and therefore you have resigned from that particular post. So I'm reading it from this point, this line. The fact that Mr. Alok Kumar resigned from the post of director after 6 months indicates that Mr. Alok Kumar realized that there may be some conduct issue on his part, and accordingly he tendered resignation from the post of the directorship. Hence, the conduct of Mr. Alok Kumar cannot qualify to be above the board and creates doubt about his independence in professional conduct. So even if he has resigned from that post, he has still contravened the provisions of the law, and therefore he cannot be, given a clean chit. So what was the final order? DC notes that Mr. Alok Kumar compromised his independence as a resolution professional by accepting the directorship of Silvertone Papers Limited, director of which was having substantial shareholding in the corporate debtor, and one director of the corporate debtor was having shareholding in Silvertone Papers Limited. This is against the code of conduct prescribed by the board for IPs. Under section 220 of the code, read with regulation 13 of the investigation rules, finally he was suspended. His registration was suspended for 3 months. So this was the final order. So if you are not taking care of your independence, then it might happen that your registration might get suspended. So this was the case of Mr. Alok. Is there any question? No. So any takeaway from this part? Do we take care of related parties at the time of doing our assignments? Do you prepare a list of the related parties, any of you? And if you are not doing, please kindly do so. If you are not preparing that kind of list, whenever you have an assignment, simply check who are the related parties, and it should be made sure that you do not become anyhow related to, or you get get into some post in you get into some kind of work or any related assignment in those related parties. That is very, very important, because sometimes it might happen that we are so much engaged in our regular work, we do not keep track of all these things, and it is very cumbersome how to take care of all these things. So whenever any assignment is given to you, you have to make a checklist of these related parties. That is very, very important nowadays, because actions are being taken in this regard. So your independence should not be compromised. And again, a disclaimer or a disclosure has to be given from the side of insolvency professional, that if he at all is related to any of the parties. Any question from any one of you till here? Or shall we proceed for the next case law? Okay, I'm taking up the next case. Okay, the third case, again, I'm taking for the sake of our professionals only. This is the order by disciplinary committee, which is a very, very recent order, 14th May 2024, and it is in the matter of Mr. Ankit Gupta, insolvency professional. Here, what we will be discussing is, I'm just telling you in short, and then we will discuss in detail. While identifying the claims, when you have the claims of the financial creditor and the operational creditor, generally it is our duty to collate all the claims, right? So at the time of collating the claims, suppose if if an issue is going on or any case is going on any financial creditor and some decision was passed for that particular person, you have to be very, very cautious what was the decision passed on that particular person. Like in this case, we will see that there was a person who claimed himself to be the financial creditor, and he filed a Section 7 application for this particular corporate debtor. But NCLT clearly dismissed his application or rejected his application, saying that you are not a financial creditor. Then later on, some operational creditor filed a CIRP application on the same corporate debtor, and it was admitted. And later on, that person who claimed himself to be financial creditor submitted his claims, and the insolvency professional, while admitting the claims, he put down that person. He took that person as financial creditor, though he was earlier rejected to be a financial creditor, but the insolvency professional somehow took him to be as financial creditor based on his own impression, or based on his own judgment. He took that forward, and on that particular thing, this complaint was raised, that how come when NCLT is clearly saying that this person is not a financial creditor, how can resolution professional take him as a financial creditor? So that is the thing which we are discussing in this particular case. Let me start with the facts of the case. So Section 9 application was filed by DSV Air and Sea Private Limited. Here the corporate debtor is Bio World Private Limited. IRP is Mr. Ankit Gupta, and the concerned party is Messrs. Prayag Polytech Private Limited. Why I have mentioned concerned party? Because this party is claiming that he is a financial creditor, but his application was denied and he was not considered as a financial creditor by the NCLT. And therefore, we have just mentioned him as a concerned party here. What is the fact of the case? Based on the findings of the investigation, as mentioned in the investigation report submitted by the investigating authority, IBBI formed a prima facie view and issued a show cause notice to the insolvency professional, that is Mr. Ankit Gupta, wide letter dated 27/10/2023. So a show cause notice was issued to this Mr. Ankit Gupta on this particular date. The show cause notice alleged contraventions of several provisions of the code: the IBBI Insolvency Resolution Process for Corporate Persons Regulation 2016, that is CIRP regulations, and the IBBI Insolvency Professional Regulation 2016, that is IP regulations. So let us go and understand the like in many movies and serials, you say, let us have a flashback. So why this notice was issued to him? So the current status, the notice was issued to him, but why this notice was issued? Let us go to the story which is in flashback. We have to see that this notice was obviously replied by the insolvency professional in time, but what happened then, we have to see that. Prayag Polytech had earlier filed an application under Section 7 of the Code before adjudicating authority for initiation of CIRP of the corporate debtor, and the adjudicating authority, by its order dated 5th September 2019, had dismissed the said application, and with a cost of rupees 1 lakh on the ground that the Prayag Polytech was not able to demonstrate the existence of a financial debt. See, when NCLT is dismissing the application, it is also putting a penalty of 1 lakh rupees on the ground that this particular party could not establish himself as a financial creditor, and they have wasted a lot of time of the court. So a penalty was also levied on them. Prayag Polytech preferred an appeal against the order dated 5 September 2019, that is the above order, before the Honorable NCLAT. However, later, Prayag Polytech withdrew the appeal, but with the request that the cost imposed by the adjudicating authority may be set aside. So here in this particular slide, we can see that Prayag Polytech, one of the parties, they filed an application of Section 7 of the code, saying that they are the financial creditors and this particular corporate debtor should be taken up for the CIRP, but they could not establish themselves as a financial creditor. So their application was totally dismissed. Now, they again filed an appeal against this particular order of NCLT, but again, they withdrew that appeal also, saying that just remove this penalty which was levied. So we are ready to withdraw this appeal, but please kindly remove this penalty which is being levied. Honorable Enclad, in its said order, had mentioned that the appeal stands withdrawn unconditionally without reserving the right to challenge the same very impugned order. So finally, that appeal was withdrawn, and this was settled already. However, Mr. Gupta here is the insolvency professional, accepted the claim of Prayag Polytech, thereby ignoring the aforesaid finding of the adjudicating authority. So that was the earlier case. Then Prayag Polytech had filed Section 7. Post that, Section 9 application was also filed and that was admitted. So based on Section 9 application, CIRP proceedings started, and wherein Mr. Gupta was appointed as a resolution professional. Then when they asked the creditors to put forth their claims, Prayag Polytech also submitted their claims, and Prayag Polytech was admitted as financial creditor by this particular insolvency professional. So that is what the case we are discussing. So I'm reading it from this line. Further, Mr. Gupta had conducted the first COC meeting with the only financial creditor, Prayag Polytech, wherein the resolution for appointment of Mr. Gupta as RP was passed by the COC. Honorable Enclad, in its order, had mentioned that the appeal stands withdrawn unconditionally without reserving the right to challenge the same very impugned order. This we have already read earlier also. However, Mr. Gupta accepted the claim of Prayag Polytech, thereby ignoring the aforesaid finding of the adjudicating authority. Further, Mr. Gupta had conducted the first COC meeting with the only financial creditor, that is Prayag Polytech, wherein the resolution for appointment, this also we have studied. So what is the basic issue here? Whether necessary due diligence was done by insolvency professional in verification of the claim, accepting the claim of financial creditor for which NCLT had earlier rejected Section 7 application. So what should be your view? If you were in the shoes of that particular Mr. Gupta, what you could have done? Let's hear from the participants.
I have an issue here.
Yes, sir.
Now I am appointed as IRP. So how I will come to know about the past case laws of the same financial creditor application being rejected? How it will come to my knowledge?
So you are speaking in a very right manner, I would say, because जैसे ही हमें assignment मिलता है, as soon as we get assignment, we are excited enough to take it up further. We are not seeing what has happened in the past, obviously, and we cannot, open each and every situation or each and every case which has happened in the past. We cannot say that. But this particular case law tells you that you have to be very cautious if some or the other proceeding has happened in the name of the corporate debtor. Actually, this application was filed for this corporate debtor, right? So even if any litigation is pending, obviously we take care of it. So if any application has been filed earlier also for this particular corporate debtor, you have to be very cautious and you have to read the whole judgment. And if this kind of thing is happening, you have to take care of it. That is what this case tells you to take care of.
So you suggest that as soon as we get the appointment, we should search the IBBI site or NCLT site with the name of the corporate debtor,
Awesome.
or after receiving the claim with the name of the financial creditor, that whether the earlier any such cases has happened or not.
As soon as you get the assignment, I think your working should start.
Yeah. Because my query is because I faced the same situation once where
Okay.
I accepted a claim of financial creditor, and it was the only financial creditor. And after very long time, I came to know that the financial creditor was a bogus financial creditor due to an order passed by NCLT.
Okay.
So fortunately, because the matter was litigated, so I got the time. I was allotted in time. Otherwise, same DC case might have happened against me also.
Yes, sir. Yes, sir. So you are lucky enough
Yeah.
to get rescued, but here Mr. Gupta is caught, and let's see what has happened to him.
Yeah, sure, sure.
Yes, sir. So I'll be sharing the screen again. Just yeah, all these cases, you might feel that you have easily escaped, but it might not happen now onwards because nowadays they are very much strict. Regulation 13(1), what does it say? It is about verification of the claims. The interim resolution professional or the resolution professional, as the case may be, shall verify every claim as on the insolvency commencement date within 7 days from the last date of the receipt of the claims, and thereupon maintain a list of creditors containing names of the creditors along with the amount claimed by them, the amount of their claims admitted, and the security interest, if any, in respect of such claims and abated. So this is what is the duty of the resolution professional or the interim resolution professional. They have to, verify the claims with whatever they are receiving, and you have to maintain a list of the creditors with such and such details. This is what the provision is. What the DC observed here, Mr. Ankit Gupta has submitted the resolution professional does not have adjudicatory powers under the code and can only collate all the claims received by him during the CIRP. So this para is again very important. Mr. Ankit Gupta, while he made his submission, he clearly mentioned that he is only collating the claims. Whatever he has received, he has just collated them. He has made the list of the creditor, and he has just he has just collated all those. He is not in a position to adjudicate, or he is not in a position to say that this person is a financial creditor or this person is not a financial creditor or things like that. He cannot judge that. Mr. Gupta is the representative of the corporate debtor, and his reliance on the records of financial creditor. This paragraph is again very important. The thing which I have highlighted is very important. Mr. Gupta is the representative of the corporate debtor. So whatever Mr. Gupta should do, he should do in favor of the corporate debtor. However, what he did was something opposite. Let us read this para and then we will discuss. Mr. Gupta is the representative of the corporate debtor, and his reliance on the records of the financial creditor rather than on the records of the corporate debtor is not correct, especially in view of the prima facie finding of the NCLT that Prayag Polytech has not been able to establish a financial debt. So I have not taken all the facts of the case because that would have been made this very long. It was simply that while collating the claims, he also checked whether how much amount is due, because he did not admitted the full claim. He admitted only a partial claim. So why he did so, and everything is mentioned in that case. Particularly, you can go and check what was there. But what he actually did was Mr. Gupta checked the financials of corporate debtor. At the same time, he checked the financials of the this Prayag Polytech also. In their balance sheet, they had mentioned that they have given loan or something to this corporate debtor. So Mr. Gupta is relying on the records presented by Prayag Polytech. They are not focusing what is how this thing is being presented in the financials of the corporate debtor. They are not looking at that. So that is why DC is saying that Mr. Gupta, that is the resolution professional here, he should consider the situation from the point of view of the corporate debtor. He should step into the shoes of the corporate debtor, and then he should analyze the situation. He should not consider himself as a financial creditor and take his records and do according to the records of the financial creditor. He should actually consider the record of the corporate debtor only. He should not take the proofs of what is mentioned in the records of the financial creditor. That is given in this paragraph. Then there is an observation of an authority on a particular question of law. This paragraph is again very important. Whenever there is a observation of an authority on a particular question of law or fact, An insolvency professional must be more cautious and vigilant while dealing with it. So, sir, as you were saying that how will we know that there were any cases or litigations happening before also? But again, disciplinary committee is simply saying that you have to be very much cautious. Every insolvency professional has to be cautious and vigilant. If there has been any observation in the past, or if an authority has made some decision which is on a question of law or fact, so any kind of decision you have to be aware of. So this is what they mean here. In the present matter, Mr. Ankit Gupta, while verifying the claim of Prayag Polytech, was required to be more specific and surgical to satisfy the observation of the existence of the financial contract. The scrutiny of claim of financial creditor needs to be conducted with reference to the financial statements and books of accounts of the corporate debtor, and is very much under the scope and ambit of the verification duty of a resolution professional, and does not in any way enter the realm of the adjudication. So since in his submission, Mr. Gupta said that I cannot, I judge this person as a financial creditor or an operational creditor. I am only collating the claims. For that, this is the comment or the observation by the disciplinary committee, that it is within his scope only to verify the claims, and by with the reference to the financial statements and books of accounts of the corporate debtor, he can very much verify the claims of a person, whether he falls under the category of financial creditor or operational creditor or nowhere. Prima facie, the financial statements of the corporate debtor support the contention of the corporate debtor put before the learned NCLT. The DC finds it strange that Mr. Ankit Gupta has sought to rely more on the documents produced by the financial creditor rather than the documents available with the corporate debtor. Mr. Gupta has selectively utilized the documents which supported the claim of Prayag Polytech while ignoring the financial statements of the corporate debtor, which should be relied by a representative of the corporate debtor. So again and again, DC is of the view that Mr. Gupta should only consider CD's view, the corporate debtor's view. He should never accept the view of the other party. Therefore, he has acted against the interest of the corporate debtor and ignored the observations of the NCLT. Therefore, this DC finds Mr. Ankit Gupta has failed in his duty of verification of the claim and therefore contravened Section 208(2)(a) and (e) of the Code, Regulation 13 of the CIRP regulation, Regulation 7(2)(a) and (h) of the IP regulations, read with clause 1, 2, 3, 5, and 14 of the Code of Conduct for IPs under first schedule to IP regulations. So what is the final order or the judgment? The DC, in exercise of the powers conferred under Section 220 of the Code, I'm just reading it directly from here, suspends the registration of Mr. Ankit Gupta for a period of 1 year. So he was suspended for 1 year just because he he paid more attention to the financial creditor, though that might have taken time. He actually, checked each and every record. He went beyond his duty and checked the financials of the financial creditor also. I mean, that person also. So even though he has done he has exceeded his, working style and everything. He might have taken more time, I would say. Still he was punished in such a manner. So sometimes it is very much important just to be just to take care of the corporate debtor, how it is being presented in the financials of the corporate debtor. You don't have to check what is being how is it being presented in the books of other persons. You don't have to see that. So you have to take the view only of you have to take the view of the corporate debtor only. That is what this particular case tells us, right? So should I continue with the next case, or anyone else wants to share any of his or her experience?
Thank you.
Okay, sir. Okay, so next case is again a very recent decision. It was just pronounced on 30th April 2024, and it is in the matter of Mr. Ajit Gyanchand Jain, who's also an insolvency professional. So here, this is a detailed case wherein two matters were there. He was being contravened for two things. One matter, I'm just telling you in short, and then we will take up it in detail. The first matter was related to the classification of the creditor. So the classification here is in the category of decree holder. If a person is classified as a decree holder, can you take him at par with the normal financial creditors, or how it should be done? So that is one contravention. So how this has happened and what are the details, we will discuss it later. But you must understand that this particular case is related to two kind of contraventions. One is related to the classification of the creditors, wherein this term we will see decree holder, how the decree holder creditors are classified. The second matter is uh, related to situations where people suppose miss out to file the claims, and if insolvency professional, he is not receiving the claims in time, what should he do? Though the books of accounts of corporate debtor clearly say that amount is due to those persons, but if those persons have missed out to file their claim in time, whether he should keep a provision for them in their book, in the resolution plan, or how should he do it? He should completely ignore that, or should he keep a provision for it? Let me have your views first, and then we will start with the this case. Any one of you, please. Rajesh sir, can we hear you now?
Am I audible?
Yes, sir. Now, yes, sir.
Please repeat your question, please.
Sir, like in this case, particularly, we have two contravention. One is how this decree holder should be classified. What is your view regarding that?
Okay.
Decree holder, I would firstly simplify what is the meaning of decree holder. Suppose um, I have filed a case, and uh, I have got the decision in my favor that I can hold this particular property in the corporate debtor for the amount which is due to me. So I am having that decree. So I am having you can say I have a security in that particular corporate debtor, and after having that decree, the CIRP proceeding started on that corporate debtor. Then what will happen? Whether I'll be treated at par with others, or I'll be treated at a higher level, or I'll be given a priority being a decree holder. That is the case.
Because you are a secured creditor as such, your rank will be seen as that is contained in under section 53. If particularly while you are doing your distributions.
Yes, sir. It will be like that only. So that is what we will be discussing. Sometimes we all understand the meaning of secured creditor, but when a new term comes in, we must all understand that. So here the new term which they have given is decree holder. What will be the position of the decree holder? One aspect is that. The second matter which we will be discussing here is what if a person fails to file the claim, how you take that position. Suppose there are five creditors in the company, maybe financial or otherwise, but if any one of them, they have failed to file their claim, what will be the take? What will be the duty of the insolvency professional to? I mean, because they have not filed their claim in time, even after the extended time, they have not filed their claim. So, how should you take up that matter? Should you allow some provision for that person in the resolution plan, or you should simply ignore that? That since that person has not applied, we should not give him anything. He has not claimed, he should not be given anything. Santosh sir, Rajesh sir, you can also speak up.
Madam, the IP can make a contingent provision if it is in the books of accounts. It is not advisable to ignore it completely. If it is clearly mentioned in the books of accounts of CD, it is in his own interest he can make a provision as a contingent not claim received. It is better to disclose it.
Right.
I
So
think
this
we should
point we
provide
will
for
take
that.
in the case. Yes. The
I
matter
think
you
we
have
should
said.
provide for that.
Sorry, sir.
I think if that is very clear from the financial statements, whatever they are being found, then we should make the provision at least of that claim, what he should have been filed.
Right. So because what happens is everything is not crystal clear given in the code. We have to, apply our minds, and by practice and by experience only, we can figure out how the things should be done. And if we have these kind of cases, it becomes easier for us to understand that in this particular situation, we have to do this way. So if suppose this was not the case, what you could have done, as we have already got some of the ideas, that if it is clearly given in the financials, we should provide for it. But suppose I am one of the resolution applicant, and I'm saying that when a person is not claiming, why should I give amount to him? Being a resolution applicant, I'm not giving anything to that person. Will you accept my resolution plan? Or is this plan valid enough as per the provisions? Are you getting my question? If the resolution applicant is not providing anything for those persons who have not claimed, whether this resolution plan is acceptable.
Madam, the approval of the resolution plan depends upon the COC. Let the COC take a decision before accepting. At least IP should disclose this man as per books, there is a claim, but he has not submitted. Resolution applicant is not willing to accept the claim. So let the COC take. Finally, AA will take a final call. It is better
Well
in
said,
us
sir.
to.
Very well said. I mean, this particular thing is highlighted here because when IP was asked why you have taken this particular resolution plan where this provision was not made, he said that this commercial wisdom is with COC. They will be deciding. Who am I to judge? I just put forth whatever was given to me. I have given it to them. But then disciplinary committee said one thing, which is very, very important. Any one of you can you analyze what could be that point? Because they are there to find some or the other fault with the IPs only.
Ma'am, in my opinion, IP should recommend to the COC that there is list of some creditors which have not filed their claim with the IP. And in that case, he can recommend the COC also to make a provision to recommend to the RA to make a provision that gives some specified time till the date of approval of resolution plan by the adjudicating authority, so that if any claim comes within that period, that should be considered by the COC.
Perfect, sir. Perfect. At least you are, thinking in advance and saying that we should make a provision or something like that. But here in this particular case, IP did not do anything like that. They simply put forth whatever plan they received. They just put it for the COC to handle. And therefore, DC says that firstly, it is fault of the insolvency professional. Why it is a fault of insolvency professional? Because he has to, there is a checklist, what all a resolution plan should have. As we all know, the resolution plan should meet certain criteria, and it was not fulfilling one of the criteria, which was that if any person has some kind of claim, it should be mentioned in that particular resolution plan. It should have a provision in that. So in that way, disciplinary committee has taken an action on this particular insolvency professional. So I think you all have got a brief idea what this case is about. Let us have the facts of the case, and then let us discuss how this matter finally settled and what was the action taken on the poor insolvency professional. Let us see that. I'm just sharing the screen again. Sometimes things they seem to be very simple, but in reality, actually, they might have these kind of complications. So we are discussing the case of Mr. Ajit Gyanchand Jain, who is an insolvency professional. Since I am telling you that this case comprises of two contraventions, so I am dealing with the first one right now, and then we will discuss the second one. However, the order was passed for both of them, so the order will be discussed together. The facts of the case: CIRP was filed. CIRP started under Section 7. Financial creditor's name here is Asset Care and Reconstruction Enterprise Limited. Corporate debtor is Messrs. How should we say it? Sare Gurugram Private Limited. Then IRP or RP, because he was finally approved to be the RP also. So Mr. Ajit Gyanchand was earlier IRP, and then he was allowed to become the RP also. What are the facts of the case? The board received a complaint via email dated 11th August 2023 from one of the home buyers of the corporate debtor. So who filed a complaint here? As we know, any of the stakeholders can file a complaint. So this, since this was an construction company, so home buyer is one of the stakeholder, and they filed a complaint against this particular insolvency professional. Pursuant to such complaint, the board, in exercise of its powers conferred under Section 218 of the Code, read with Regulation 7(1) and 2 of IBBI, Inspection and Investigation Regulations, appointed an investigating authority to conduct investigation of Mr. Ajit Gyanchand Jain in CIRP of the CD. See, in all these cases, in disciplinary committee cases, you will find that how it started. Firstly, the complaint has been put to IBBI, then IBBI appointed an investigating authority, then the investigating authority gave a notice to the IP to reply on various contraventions. Then IP would reply within the given time, and then based on the investigation report, which is prepared by this investigating authority, IBBI will finally issue a show cause notice, and then this matter will be taken up by the disciplinary committee. So that is how this whole procedure goes. It was observed that 11 home buyers had a decree in their favor awarded by various authorities such as Consumer Forum or RERA. So decree here is just the court order which these home buyers had got in their favor, that they will have a priority at the time of payment or something like that, or they will be given their money to whatever it was. So they already had a decree. That is what it is saying. And this decree was awarded by either the Consumer Forum or the RERA. Some authority gave them a decree. Based on the claims filed by them, Mr. Ajit Gyanchand Jain sought a legal opinion with regard to the nature of the claim of these decree holders from two different advocates. Normally, whenever an insolvency professional has any kind of doubt, he can always take help of the legal counsels. So, and this is also a part of CIRP cost. So he has taken opinion from two different advocates, to understand the nature of the claim of these decree holders. How should he place them in the waterfall mechanism? How should he treat them in the waterfall mechanism? He admitted the claim of the aforesaid decree holders as creditors in class based on the legal opinions. However, it is observed that despite having admitted the claims of these decree holders as creditors in class, he has treated the claim of the said decree holders as other creditors in the resolution plan placed before the COC instead of creditors in class. So this para is important to understand, because here it is given what has happened. So normally he, according to the this opinion which he got from the advocates, he declared these people as creditors in class. However, in the resolution plan which he received, there was no mention of creditors in class for the payment. It was only mentioned payment to other creditors. So this whole category of creditors in class was lost somehow in this resolution plan. The facts and circumstances as observed during investigation show lack of integrity, and utter negligence in handling the CIRP. The above acts and omission on his part is unprofessional. This is what the view of DC here. So they are saying that if an insolvency professional is negligent in such a level that the category or the class of the creditors he's missing out, he's earlier he defined them as creditors in class which is in priority to all other creditors, but here while accepting the resolution plan he is just accepting the plan for other creditors. So that way there is a kind of negligence. This is what is the view of the disciplinary committee. The board held the prima facie view that Mr. Ajit Gyanchandji Jain, has contravened section 32E, 32F, and 208(2)A and E of the code, regulation so and so. I'm reading it directly. So these are the various contraventions as per the board. The IBBI is of the view that he has contravened so much of the provisions. These many provisions he has contravened just by classifying it in a different fashion. Earlier he had classified it in the other category, and now in the resolution plan he has completely ignored that category. So thereby all these contraventions are there. So what is the exact contravention put by the IBBI here? Differential treatment of the decree holding home buyers in the resolution plan of the corporate debtor. The issue before the DC is the treatment of the home buyers who hold award or decree as financial creditors in a class during CIRP and later changed to other creditors in the resolution plan of the corporate debtor. So this was said to be the contravention. Now, what is the observation of DC? It is pertinent to mention that it is the duty of the RP to ensure that the resolution plan ought to be in consonance with regard to the classification of the creditors, and no differential treatment is accorded to the creditors in the resolution plan which could jeopardize the interest of the creditors. Obviously, in this case, when you are treating it in a different fashion, the priority order is changed, then obviously it will jeopardize the interest of the other creditors. So that is why this this was the observation was made by the DC. Further, with regard to voting mechanism under the code, only financial creditors have been given voting rights. However, in the present matter, home buyers who hold award or decree were treated as financial creditors in a class, participated and voted. On the contrary, they have been classified as other creditors in the resolution plan to whom voting rights cannot be bestowed. The DC is of the opinion that Mr. Ajit Gyanchand Jain has treated home buyers who hold award or decree in an inconsistent manner, resulting in contentious and convoluted process. It is imperative for an RP to perform his duties. This para is again very, very important because this is the major observation of DC. It is imperative for an RP to perform his duties with utmost care and due diligence without any influence from third party and must maintain integrity, be straightforward and forthright. The conduct of Mr. Ajit Gyanchand Jain for treating the home buyers who hold award or decree as financial creditors in a class during CIRP and later changed to other creditors in the resolution plan of the corporate debtor, the DC finds that Mr. Ajit Gyanchand Jain has failed to act in the interest of the creditors and conducted the process in manner which is inconsistent, negligent, and non-transparent manner. So till here, the first contravention is finally resolved. What are the observation of DC? So whenever in practice also, whenever you are whatever you have categorized whatever way you have categorized your creditors, the same should be there in the resolution plan. So again, while obtaining the resolution plan, see, normally what we people see is that we are getting any resolution plans or not, and how much amount we are getting in the resolution plan. We are just looking that. But here DC is saying that you should also see whether the same categorization of or the classification of the creditors is done the way which you had asked, and if it is somewhat different in the resolution plan, then again it is a kind of contravention on the part of RP, as if that he has not performed his duty well. So you have to check this always. Any question till here? So besides the duties which are mentioned in the code of conduct, wherever, again, these kind of judgments put forth a variety of, duties for us, that we have to be very vigilant. We have to take care of all these matters again, otherwise we will be punished. That is what these cases tell us. Now let us understand the facts of the second case in the same particular case law, that is of Mr. Ajit. In the same case, we have second contravention. It is observed that the resolution plan of the consortium of KGK Reality India Private Limited and Dhoot Infrastructure Projects Limited mentioned that for the units of flats for which no claims had been received as on the date of submission of plan on 20th November 2021, whichever is earlier, no consideration would be paid for such claims. So I'm reading it again. It is very, very important because what is mentioned in their resolution plan, the resolution plan which was submitted by a consortium of two parties, they mentioned clearly that for the units of flats for which no claims have been received as on the date of the submission of the plan on 20th 11/2021, whichever is earlier. So whenever they had submitted the plan or this date, whichever is earlier, if no one has put forth their claims, if they have not received any claim, no consideration would be paid for such claim. They have clearly mentioned it in this fashion. Like earlier when we discussed, one of the participants mentioned that a provision should be made if anyone has not claimed a provision, separate provision should be made. But here the resolution plan itself says that nothing will be paid to them. So whether this kind of statement should be accepted by the insolvency professional, so that is where the contravention is there. So we are dealing it in this manner. Further, the said plan mentioned that all monies paid in relation to such units of flats shall stand forfeited, and all claims in relation to such units of flats shall be fully and finally settled by the resolution applicant by way of payment of nil consideration. So this was a paragraph mentioned in the resolution plan itself, that nothing will be given to them, and if they have paid anything, that shall be forfeited. So is this acceptable? So that is where the question lies. There was a list of 281 flats which was annexed with the resolution plan. Accordingly, Mr. Ajit Gyanchand Jain, who is the resolution professional here, was aware about the details of such units of flats which were already sold. However, no claims were received against these. Thus, it is observed that he had presented a resolution plan before the COC where there was no provision for such unclaimed units of flats, even when Mr. Ajit Gyanchand Jain was aware about the details of such units or flats. Considering the fact that real estate projects have large group of people, there is a possibility that all these allottees or home buyers could not have been able to file their individual claims. However, details of such allottees or home buyers were available. Were available in the books of accounts and other records of the corporate debtor. Therefore, Mr. Ajit Gyanchand Jain was under the duty to safeguard the interest of such home buyers. So again and again, it is mentioned that it is the duty of the resolution professional, if he is aware that some claims some claims were not filed by the, though they were genuine, but they were not claimed by the people, then he must pay extra care for that. That is what this case is all about. And especially it is saying that in case of real estate or in case of home buyers, it may happen that because of large number of people, there might be cases where there might be some cases where people are not able to file the claims timely. So there in those situations he has to be more cautious. So the contravention specifically talks about the non-inclusion of the provision for unclaimed units or flats. So what is the observation of DC? The DC observes that Mr. Ajit Gyanchand Jain has not denied his awareness about the details of the unclaimed units of the corporate debtor. See, DC always starts saying that IP knows everything. Here, Mr. Ajit also is not, he is also aware. He is not denying the fact that there were some unclaimed units. So he is very much aware. And since he was aware, it should be his duty to, take care of all those circumstances. That is how they will proceed. In real estate projects, it is the duty of the RP to position the correct and factual details of the units in the information memorandum in the terms of payment, possession, and ownership, if any. So normally it is a due. They have mentioned that in information memorandum, everything should be mentioned with respect to payment, possession, and ownership. The claim of those home buyers who could not file their claims but whose claims were reflected in the record of the CD ought to have been taken note of, and resolution applicant should have appropriately dealt with them in the resolution plan. Non-consideration of such claims, making value of such claims as nil, forfeiting part payment made by such allottees, and cancellation of allotment of such units in the resolution plan does not seem to be inequitable. In view of the foregoing discussion, the DC holds the contravention and finds that Mr. Ajit Gyanchand Jain has failed to act as per these sections. So he is held guilty. The DC finds Mr. Ajit Gyanchand Jain in contravention of all these sections. And finally, what has been the consequence? He has been suspended for a period of 2 years. So for 2 years, he is being suspended. So you have to take care what you are getting in resolution plan also, whether the classification is correct or not, whether proper provisioning is done for the unclaimed uh, 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 people, unclaimed creditors also. You have to be very cautious of all these things also. Any comment till here?
Ma'am, is this applicable only for the home buyers cases like real estate projects, or any other CARP cases also?
It's applicable on all. Basically, what in this particular big sense, it was in the case of home buyers, it is very much important because there they are in large numbers. So we have to be extra cautious in those particular real estate cases. So even if it is not there, I mean, the big cases you have to be very cautious in those cases. But in smaller cases, you can easily judge. I mean, if there are only 10 creditors, you can easily check out whose claim is received or whose claim is not received. You can check with them, you can get them, you can connect with them and get the claims. And if you are not getting the claims, and if it is a genuine claim, you should do the provisioning for that. That is what is required. So this is just one of the examples which is, taken up by the DC so far. It might happen in other cases also.
What are the resolution plans he is receiving? They are to be presented to the COC, right?
Right, sir.
So, I think what's his role has gone wrong somewhere, because ultimately what he needs to do is he needs to get it done and present it to the COC. Ultimately, COC will be the parent body who will decide whether to go ahead with that or not. Yes, no doubt that provisioning should have been made or that classification was wrong. That is understood. But I think he should have the role of presenting that to the COC, whatever the resolution plans he has received. Is there still a fault from him to present that also?
So when a show cause notice was issued in this case, now the insolvency professional, when you will read the case, now you will understand what all submission he has given. He has simply mentioned that it is not my fault. I have presented whatever I have got to the COC. It is up to them. It is their commercial wisdom. They have to, check each and everything, whether everyone has got equal share or not, whatever share proportionately, I mean, whether they have got according to that or not. But DC here is of the view that the first and foremost duty, by having these resolution plans, firstly, we as an insolvency professional, we must check whether it is complying with the particular provision as mentioned in the code, that resolution plan has to abide with certain conditions. It has to have, the waterfall mechanism order should be there, and then time of payment should be mentioned, and all those criteria which is given in the code. It should match with that. If insolvency professional is lacking in that, then it is his fault. After checking everything, if he's not there to judge whether this plan is good enough for the COC or not, he's not checking that. His duty is just to check whether everything is complied with or not. If the provisioning part is not there, it is in his power to reject that also, because this is not matching with the criteria. He can simply outrightly reject that plan. But if he is putting forth that plan, it simply means that out of many resolution plans, he has shortlisted the ones who are meeting the requirement of the law. And then once he has presented, then it is the duty of the COC, because COC will not check it from the legal angle. They will just check it from whether whether it is commercially viable for them or not. So DC is of the view that the legal part is to be first ascertained by the insolvency professional, and then it has to be put forward. That is what basically it is dealing with. Though obviously any insolvency professional will take shelter of this view and say that how can we judge this thing, but that is how this case is put.
No, there are, for example, that kind of thing like provisioning was not properly made or classification was wrong, no doubt that that were the faults. My only point is, RP has no role to play, particularly, or he should not be judgmental in the sense that whether that is going sailing through properly or not. Because ultimately he has to present that all whatever that resolution plans come up for him. And the parent body is COC ultimately. So they will decide. That is what is my sense. I may be wrong.
No, so it's perfectly fine. But just assume yourself to be in the shoes of Mr. Ajit. What would he do? I mean, he was, suspended for 2 years. Now, what can he do? He would take this, he will take this, advice from the DC that in next cases, he will be more careful. That is what he can do. Because I don't think we can argue it or appeal it any further. I don't think we can. Because disciplinary committee has given this, and if at all, if you can take that forward, if you can appeal it further, you may say that. But very rarely things are in favor of IP. In each and every way, IP is being pressurized to pursue these assignments.
No, particularly in this case, if he has admitted his fault, then there is no recourse for appeal also.
Right. So let it be, sir. Yes, sir. So I've taken these 3-4 cases for the disciplinary committee only, and then I will now proceed with the High Court case. You all want to take a break, or should we continue, as you say?
Let me continue other participants.
Should I continue?
Yes,
ma'am.
Okay. I'll just share the screen again. So we are now dealing with some important judgment of High Court. So normally what happens is we have various levels of authority like NCLT. So we can have orders from NCLT. Then if you want to go at a higher level for appeal, if you are not satisfied with NCLT, then you can appeal to NCLAT. So that is National Company Law Appellate Tribunal. So then if still you are not satisfied with the orders of NCLAT, you can go further to High Court, and then it is Supreme Court. And in the case of disciplinary action, there is a complete different mechanism. Disciplinary committee is there, which takes care of each and every professional misconduct or things like that. So if I'm talking about this High Court judgment, This is to do with the procedural part, basically. And here, normally in High Court decisions, question of law is being discussed. So let us see what is the judgment about. So, as the name suggests, Mr. Shiv Charan and others versus adjudicating authority of PMLA. So PMLA, normally we are hearing about this authority again and again because it is related to this money laundering act. So they also have an authority to, confiscate or hold the property. And what will happen if PMLA has already hold of the property, or it has the possession of the property, and meanwhile the CIRP proceedings are, they have started. So whether the moratorium will keep a hold on, will keep a check on this PMLA proceedings also, because again and again this is being asked whether uh, which act is supreme. I mean, whether IBC provisions are at superior authority, or whether PMLA can also, continue taking action on its part. So that is where a lot of cases and controversies are there, and this is one of the decisions wherein we will also check how these things have happened. So normally, what happens in case of IBC, uh, during moratorium, other people cannot file a case on the corporate debtor. So they cannot seize the property of the corporate debtor. But what if any proceeding is going on under PMLA Act or customs or any other thing? So what will happen in that case? So we are just dealing with one of the cases regarding this PMLA authority. What has happened and how this was resolved. The present cross writ petitions involve writ petition number so and so filed by Mr. Shiv Charan and others, hereinafter referred as petitioner 1 to 3, respectively, against the adjudicating authority under the Prevention of Money Laundering Act 2002, Department of Revenue, Ministry of Finance, and Deputy Director, Directorate of Enforcement Directorate, etc., seeking to invalidate the enforcement case, information report, and orders attaching property, while writ petition number this was filed by ED, challenging the NCLT's authority to pass the order invoking section 32A of the IBC. That is, so here in the facts we can see that ED, or the authority of PMLA, they had attached the property already. However, the CIRP proceeding initiated and the moratorium was established, and now they are this thing is being challenged in NCLT, invoking section 32A, saying that this thing should be put on hold. The property which is under the control of PMLA or ED, that should be given back to the that should come under the possession of RP, so that he can dispose of, and or he may plan it in the manner it is given in IBC. The case concerns the resolution of DSK Southern Projects Private Limited, that is the corporate debtor here. The CD underwent a CIRP initiated by a financial creditor on 9th December 2021. Eventually, a resolution plan put forth by petitioners and approved by NCLT on 17th February 2023 under Section 31 of the IBC. So here the resolution plan was approved by NCLT on 17th February 2023. Prior to the commencement of CIRP, so this date is again to be taken care of. Prior to the commencement of CIRP, various FIRs alleging offences including cheating and criminal breach of trust were filed against the corporate debtor and its former promoters. These offences fell under the scheduled offences as per PMLA Act 2022. Consequently, an ECIR was filed by ED on 8th March 2018. The ECIR estimated the proceeds of crime to be approximately 8,522.27 crores, which is a huge amount. As a result of the ECIR, the ED filed an original complaint leading to attachment proceedings against the assets of the corporate debtor. So all this is happening before the CIRP. This included 4 bank accounts of the corporate debtor, totaling this much amount, 14 flats constructed by corporate debtor, valued at so much amount, referred to as the attached property. So they have attached all these properties. The attachment was initially provisional under Section 5 of the PMLA 2002 on 14th February 2019 and later confirmed by an order dated 5th August 2019 passed by the adjudicating authority. Normally in PMLA, firstly they do a provisional attachment and then it is confirmed later. So that way this was done. The attachment persisted even after the initiation of the CIRP and continued after the approval of the resolution plan, which forms the crux of the current writ petition. I'm reading this para again. The attachment done by the PMLA department, the ED, the attachment persisted even after the initiation of the CIRP and continued after the approval of the resolution plan, which forms the crux of the current writ petition. So the attachment is continuing, they are still doing, that is what it is saying, that even after the plan is approved, the attachment is still continuing. So what is the issue arising? Whether the NCLT has the jurisdiction to direct the ED to release the attached properties once the resolution plan in respect of the said corporate debtor is approved by invoking Section 32A of the IBC 2016. So what is your view? Any one of the participants may speak up before we take up the actual situation. Anybody has an idea what is the Section 32A?
Yes, ma'am. Madam, PMLA Act will prevail because it is a criminal proceedings, and the cases which are filed under PMLA Act and other criminal proceedings will continue.
That is your view, sir. Okay. Any other view?
Yeah. Divya, this is Mamta Binani here.
Hi, ma'am. How are you?
Good, good. Thank you so much. Very good session. So Section 32A is all about saying that 32A, by virtue of its law, will prevail over all others, and it mentions that it will give a clean slate to by the entire process. The buyer will get a clean slate devoid of anything that has happened in the corporate debtor, and it's only with regard to the corporate debtor, but the promoters and the CG and the PG will still not be free and will not be a clean slate. So 32A, by virtue of the act itself, will get a clean slate.
Very rightly said, ma'am. So it clearly says that CD is free. However, you can still proceed against the promoters or the guarantors or anyone like that. So let us continue with the case. Let me share the screen again.
Ma'am.
Okay, sure. Please.
Yes, ma'am. In my opinion,
Yes,
ultimately,
sir.
the date of order of the Honorable NCLT for initiating CIRP is the important date, ma'am.
Yes.
If the assets of the corporate debtor has been attached by the ED or some other agency before that date is also very important for consideration.
Yes, so because after CIRP has started, obviously they do not have that state. They cannot. The confusion arises only because PMLA says that we started our proceedings much before the CIRP. So we still have the power. That is the case they are dealing with.
Yes, ma'am. My opinion is that if they have initiated the attachment proceeding before that date and attach the property, and I am of the opinion that if that then definitely PMLA has the.
So okay, we are having two views now. Let's see who's correct. One view is that if before CIRP PMLA has attached the property, PMLA will have a hold. They will have the priority. And if PMLA is attaching during the CIRP proceedings, whether they can or cannot, again is a question. So
Yes,
if they are attaching during CIRP, then probably it is 32A that will be in the priority, that will be in the supremacy. So
yes.
IBC will have a supremacy in that.
Yes.
So I think you all have, I think I have the attention of everyone then. Let's see how the case unfolds. Let's see. the observation of High Court. The Honorable High Court affirmed NCLT's jurisdiction in declaring that a corporate debtor would be discharged from offences upon approval of the resolution plan under Section 31 of the IBC 2016. Honorable High Court further stated that protection to corporate debtor under Section 32A apply upon approval of a qualifying resolution plan, ensuring a clean break with a charge in the ownership. So that is what Mamta ma'am just mentioned, that they will have a clean check. The corporate debtor will be free of it. That is what this para says. The Honorable High Court further observed that since Section 32A confers immunity from prosecution, continued attachment under PMLA would be illogical. It is also clarified that the jurisdiction under Section 14 of the IBC 2016 seized upon the commencement of Section 32A, making conflicts irrelevant. The court emphasized that the approval order for the resolution plan by the NCLT dated 17th February 2023 was not challenged by the ED, required the release of the attached properties under Section 32A. The Honorable High Court further concluded that NCLT's interpretation and application of Section 32A did not undermine the PMLA 2022. The Honorable High Court further stated that quasi-judicial authorities, when exercising powers akin to civil courts within state agencies like ED, play a distinct role separate from the executive functions. They serve as a statutory checks on the executive bound by the Supreme Court rulings as per Article 141 of the Constitution. It's imperative that such quasi-judicial bodies adhere to Supreme Court decisions to prevent unnecessary legal disputes, ensuring compliance with the rule of law. What is the final judgment? The Honorable High Court ruled that the attachment by ED over attached properties, including 4 bank accounts and 14 flats of the CD, seized on 17th February 2023, pursuant to Section 32A of the IBC. It is mandated that the respondents in writ petition number 9943 and the petitioner in writ petition 29111 must promptly communicate this release to the corporate debtor with a copy sent to the petitioner within 6 weeks of the judgment. So this is done. This communication is vital for using the attached properties as bankable assets to revive the corporate debtor in line with the objects of the resolution. So finally, what is the conclusion? You all could understand, or should I take you again with the previous slides? This para itself is clear enough. The Honorable High Court ruled that the attachment by ED over the attached properties, including 4 bank accounts and 14 flats, seized on this particular date pursuant to Section 32A of IBC. As soon as the resolution plan is approved, the PMLA will not have their control over the attached properties. This will have to be handed over to the resolution professional to make them a bankable assets, as this is mentioned here, to revive the corporate debtor. So now this is very much clear that even if the proceedings had started earlier also by PMLA, they will not have the hold, or we can simply say that IBC has the supremacy over PMLA in the case of attached properties. Any comments still here?
Ma'am, what happens if the plan is not approved and it goes into liquidation or whatever?
So in that case, because the plan is not approved, in that case, since they have highlighted the fact that once the plan is approved, it is the IBC which will prevail. What I feel is if that is not happening, then PMLA can still take care of they will continue their proceedings.
Thank you.
But ma'am, here
Madam,
is
one more thing.
Yeah.
Yes, sir.
Please share this case title of this case, a reportable judgment.
Sure, sir. This is the case.
Sure.
So
Ma'am,
yes, sir.
one clarification. In this judgment, one comment is also there given by the Honorable High Court, ma'am. They have not filed an appeal.
Yes, sir, of course. They have not filed an appeal. It is only High Court decision.
Or we may say the PMLA has to file a claim against those attached property with the RP or IRP at the case made.
It may happen, sir. It is just the High Court decision so far.
I am just seeking clarifications or guidance from your side, because ultimately the attachment proceedings were initiated before the date of the CIRP order,
Right, sir.
and property has also attached earlier.
Yes, sir.
Because the PMLA has not filed any claim, or we can say they have not filed any appeal. This is also one of the finding by the Honorable High Court also.
Yes, sir. Mamta ma'am, we would seek your guidance also here.
Yeah, ma'am, please guide us, ma'am, on this.
Mamta ma'am, are you there? Normally what happens is, what is my view, not in this regard only. Whatever judgments are coming in, I mean, every time there is some or the other change, whatever rule we set in our minds, that is, surpassed or, overlapped with some other things. Even in this case, there might be a situation where Supreme Court comes in and they present their different view, or maybe they present some other things in this particular case. But so far as the things are settled, I mean, this PMLA Act is this will have a lesser role as compared to IBC. So IBC will have a supremacy so far as this case is concerned. This is what I can say.
I agree, ma'am. I agree, ma'am. My question is that only this conclusion is subject to this comment.
This comment only, yes, sir. Yes, sir. We still have to wait for the Supreme Court decisions. Maybe in some later sessions, we will be discussing that also.
Okay, please.
But this is a very, I mean, this is a very hot topic these days. What will happen to the attached properties if it is attached by SARFAESI or PMLA or any other body like that? So what will happen in the case of IBC? So these are taking much more concern these days, and therefore we should be very much aware of the situation, what is happening in the recent decisions. We cannot, just stick to our old uh, old methodology or whatever we had assumed earlier, because every day this law is evolving and new approaches are coming into, and uh, new things are decided by the court, giving some or the other, judgments like that. So we should be aware of the new judgments. That is what the basic idea of having these kind of sessions. And obviously, nothing is final, full and final, nothing is there. So every time you can file an appeal and this will change. So at least we should be logical enough to understand why this has happened. And if we are able to understand the logic, that is the best thing.
Yes. Yes. Thank you.
Okay, let me move further. So next I have taken one of the NCLT judgment, Mr. Neptunus Power Plant Service Private Limited versus Messrs. Jackson International Limited. So what are the facts of the case? Let us see. The present application was filed by Messrs. Neptunus Power Plant Services Private Limited, hereinafter referred as applicant, before the adjudicating authority under Section 9 of the IBC for initiating the CIRP against Messrs. Jackson International Limited, hereinafter referred as respondent. So application is simply filed by Messrs. Neptunus, and the respondent here is Messrs. Jackson. This is what we should understand. And who has filed the application of Section 9? Section 9 application was filed by this Neptunus against this Jackson. So Jackson is this corporate debtor. The applicant claimed that the respondent defaulted to clear the outstanding amount of this much amount along with the interest at the rate 18% per annum and the date of default being 18th March 2020. Actually, this is a case of MSME. Let me discuss the facts in short here. In case of MSME, what happens nowadays? This thing is again being it is being taken up as a hot topic nowadays because of Section 43BH, and it is saying that income tax in income tax, this particular section, it says that if MSMEs are not paid within 45 days on that particular amount, that shall be disallowed and tax shall be supposed to be paid by the persons who have not paid, obviously. So this is basically dealing with the MSME part, and if MSME's outstanding amount is this much, and they are saying that our interest portion is also this much which is pending. However, normally MSMEs, they do not enter into any written agreement or written contract with the parties. It is just the verbal thing, verbal contracts are there. So it is talking about it. This case will mention basically when there is nothing said about the interest element, whether that interest will form part. Okay, let me just tell you how this interest is calculated. As per the MSMED Act, it says that if the amount is not paid to any MSME within 45 days, then 3 times the bank rate. 3 times the bank rate. Get this very clear, that if the bank rate is 6%, then 3 times, that is 18%, will be the interest rate which is supposed to be paid by this by the corporate debtor to the MSME. So the MSME Act mentions the interest rate and the time when this interest will become due. However, there is no clear-cut contract between MSME and the corporate debtor normally in this regard. So what will happen? How this will be taken care in IBC? Then this MSME will submit his claim. His claim is suppose amounting to rupees, suppose just it's amounting to rupees 90 lakhs only. And if he is adding that interest element, his amount is becoming 1 crore. His claim is becoming 1 crore. So the logic is, or the question here is, whether any operational creditor who's an MSME, can he file an application in section 9 saying that my original amount is 90 lakhs plus interest amount, it is making the amount to 1 crore, and thereby I am filing an application against this particular corporate debtor, and thereby this CIRP proceeding should be initiated. Because if you are not adding that interest element, the amount is lesser than 1 crore, which is the threshold limit, and therefore this application might be dropped or dismissed. So the question here is, if there is no clear-cut agreement between MSME and the corporate debtor, will that interest element, which is mentioned in MSMED Act, whether that will be given here also, or that will be added here also while computing the amount of the threshold. So before going further, let me have your views. I think you have got the idea, or should I repeat it?
No, I think if that is not contained in the invoice, then the invoice amount, whatever that is there, that should be more than 1 crore. I mean, the threshold has to be crossed by the overdue amount.
So interest should not be considered. That is your
If that is not there in the invoice, as we are just saying.
okay. Any other view?
Ma'am, in my opinion, if the condition of interest is duly accepted by the corporate debtor, I think then in that case only interest will be considered. Otherwise, because IBC is not recovery proceedings and in MSME, then definitely interest is separate but for recovery purpose. here IBC, these proceedings are not recovery proceedings.
So again, one question here. Suppose you are accepting the claim of that person, of any person. Suppose this has gone into CIRP proceedings already. Let us assume that way. And there is an MSME which is claiming that my dues are 50 lakhs. So at the time of admitting the claim, do you allow him the interest from your side, or only when he claims the interest then you allow it?
Ma'am, if the interest term is duly accepted by the corporate debtor at the time of supply or before that, while issuing order for that purpose, in that case only interest will be included. Otherwise, interest will not be included. This is my person.
Okay. And in case of financial creditors, it is always included.
If it, in case of financial creditor, if there is agreed terms, agreed agreement, agreed terms and conditions are agreed by the corporate debtor, then interest will be included whether that is financial or operational credit. There is no difference.
So according to you, written agreement has to be there.
Yeah.
And if clear terms are there with respect to interest, only
Yes.
then it has to be taken in, whether at the time of accepting the claims or whether at the time of filing the application.
Or otherwise, if there is some order from some adjudicating authority or some honorable courts, in that case goes.
Absolutely. I agree with what Mr. Subhash is saying. The CD has to accept whatever that is contained as overview on it.
We cannot hear you, sir, again.
But acceptance of CD is important.
Acceptance of CD is important.
Yeah.
And if CD does not accept, then it should not be considered.
Yeah, then only principal or the overview amount we need
So
to
why
consider.
would CD accept?
But if that is not being accepted, then that claim itself may not be sustaining in that case. If the CD is not accepted or there is a dispute somewhere.
So what I presume is normally the dispute which we talk about is the invoice value. It is not with respect to the interest.
Yes.
First, to establish the principal amount is disputed, then obviously the interest would also be disputed. But if he's agreeing with the principal amount, whether, I mean, who will agree to pay the interest? No.
If the CD has accepted that interest also, then that is okay. Otherwise, only overview amount or that invoice, whatever.
So normally why we are discussing again because as per the MSME Act, it is clearly mentioned whether you have agreed to the terms of interest or not. You have to pay. That is
we have to provide for the interest, even if it is not claimed by the MSME creditor. The interest at the rate as declared in the 3 times now, we have to take into account in considering the claim submitted by the MSME, even if it is not there on the invoice. Is my view.
This is your view, sir. So we have different views. Now, please pay attention. What is the exact scenario? How this case is dealt? Because this is very important with respect to the interest element. So we are discussing this thing like at the time of filing application for CIRP, whether that interest part, will that be added in the principal amount? If even if it is not mentioned in the agreement or there is no agreement at all, just on the basis of the MSME Act, do we have to add that part or not? That is what we are discussing in this particular case. And later on, we will discuss amongst ourselves whether at the time of accepting the claims also, whether that interest element should be added or not. This is again based on this particular case. So let us discuss the case as such, and then we can share our views again. So here we can see that this respondent here, I mean this Mr. Jackson is the corporate debtor, and Mr. Neptunus, he has this entity has filed an application saying that this amount is more than 1 crore, including the interest part. Including the interest part, now he is claiming the full amount. The entire claim was based on invoices issued by the applicant to the respondent for the services rendered by him. So this is clearly saying that He's an operational creditor because this is based on invoices. The respondent acknowledged the liability by way of acknowledgement letter dated this. So the respondent is also acknowledging, the corporate debtor is also acknowledging, that means there is no dispute with respect to the invoiced amount. The applicant sent a demand notice to the respondent on this particular date and on 24th January 2020 for the debts outstanding since 2015. So since 2015, the debts are outstanding and the demand notice was sent to them on these particular dates. The respondent denied the contentions of the applicant on the ground that application is below the statutory limit of 1 crore. There was a pre-existing dispute even before the issuance of the demand notice, and the application is time barred. So these are the three contentions which they are saying that on the basis of these, this application should be rejected. The respondent asserted that the debt mentioned in the first demand notice stood at rupees 87.67 lakhs, which is 54.12 principal amount plus 33.54 is the interest element, and without prior notice, the amount was increased to 1.32 crores in the application. So let us understand this particular paragraph. The original invoicing was on this amount, 54.12 lakhs. This was the original amount. And this happened in 2015. These transactions took place in 2015. So from that date, they added on this particular 33.54 lakh interest amount. Then they sent the demand notices. So in 2020, this was the interest element for 4-5 years. Then again, they increase because this interest is calculated for every month. Every month it is calculating the interest. So again, the interest portion has increased and now the amount has increased from 87.67 lakh to 1.32 crores, which this corporate debtor is saying that without telling us, they have directly increased the amount, but the differential element is just the interest part, which is accumulating monthly. Further, the respondent alleged that the applicant has wrongly added interest amount, as no such interest amount has ever been agreed in any invoices, nor any agreement exists for the same. So what is the issue here? Basically, the issue is, can interest amount be added in case of no written agreement to meet the threshold limit of 1 crore? And again, we have to link it with section 43BH of the Income Tax Act 1961, because as per the current scenario, if any person is not paying the due amount within 45 days to MSME, then this amount will be disallowed in his books of accounts and he is also supposed to pay income tax over it. That is the view as per income tax. And as per MSMED Act, section 15 talks about the interest which is to be paid and the rate is 3 times the bank rate. So while dealing with the IBC, we have to also correlate it with this Income Tax Act and the MSMED Act. So let us see what is the observation by NCLT. The adjudicating authority observed that the applicant has not shown any clause in the invoice which specifies that interest is leviable in case of any default. So clearly there was no agreement with respect to the interest. Therefore, in such absence, the applicant cannot claim any interest. The adjudicating authority also observed that the applicant has failed to satisfy the minimum pecuniary threshold of default, being rupees 1 crore as mandated in the amendment to section 4 of IBC. Further, taking note of the averments made by the respondent and the substantiating documents provided by him, the adjudicating authority stated that the respondent was not negligent in its obligations and that the dispute existed prior to the issue of the demand notice. What is the final order or the judgment? The adjudicating authority held that the filed application fails to fulfill the criteria laid under section 9 of the code Accordingly, the application for initiating CIRP against the respondent was dismissed. So here they are clearly mentioning that they are not able to fulfill the criteria as per section 9 of the code, which is related to the amount. Obviously, they are not meeting the criteria of 1 crore. They are not fulfilling that threshold limit. So the application is finally dismissed. So ultimately, what is the conclusion? Though the MSME Act talks about the interest element, IBC does not, talk about the interest element. It is just talking about the invoice. And if there is clear-cut written agreement or any written terms and conditions are there with respect to interest, only then that interest amount shall be added to the base value, to the principal value. Otherwise, it will not be added. You can file a separate application in MSME Act and claim the interest element. That way you can proceed for it. But as per IBC, only the principal amount will be given. Any comments?
Actually, in MSMEs, there are facilitation centers, and you can very well claim that whatever you have just said, that 3 times of base interest rate. And that also could be claimed, and not only that, we have received once or twice of
Yes.
our cases.
Samadhan portal is there for MSMEs. They can themselves file an application and the interest they can claim there.
Yeah, evidential standing you need to give over there, and there are hearings used to happen. And you can
And that
get
is
your
the easier way rather than going into IBC. That is shorter
Yeah.
and easier way to claim the
Yeah.
amount.
Divya ma'am, one more guidance I see. Ma'am, in case of some order from the MSME or arbitrations authority, in suppose interest condition is not there, and if the party got some order from MSME, in that case, interest will be included or not?
So the order itself includes the interest element. Even if you have not computed it, they will pass an order, they will give a decree saying that the interest is also to be paid. So
In
that
in
is
that
mentioned.
case, in that case, interest part will be included that threshold limit or not? This is my question.
Okay, if he has got that decree, then of course that will be added.
That will be added.
This is my view because that has now been, made certain that this amount is to be claimed from the entity. Then full amount you can claim.
Even if there was no agreement, no term
Yes,
and
yes,
condition
yes.
agreement.
Once you have the decree, obviously.
Okay, thank you. Thank you.
If you people are still ready for one more case, I have one more. That is a big decision. So if you people are ready. Thank you.
Not an issue, please proceed.
Okay. Just wait a second. I'll open that. Recently, a circular was issued. If you know, it is related to the previous circular issue, and it said that it is related to the liquidation fees calculation. So there was a proper judgment based on which that circular was issued. I'm talking about the case of Mr. Amit Gupta. Is anyone aware of that? Is my screen visible?
Yes, ma'am.
Okay. So let me give you a background for this particular judgment. There was a recent circular issued on 18th April. The heading was partial modification to the circular number 61. So this is circular number 70, and it is talking about modification to the earlier circular, which is circular number 61, which is related to liquidation. and it was issued earlier on 28th September 23, titled Clarification with respect to liquidators' fees under Clause B of Sub-Regulation 2 of Regulation 4 of IBBI Liquidation Process Regulations. So basically, what was the result of this new circular? What was the result of this new circular? It had modified the earlier circular. So what was the modification? In earlier circular, in this 61 circular, there were 5 clarifications given by the IBBI. Out of those 5, 2 were withdrawn with respect to this particular circular. So which 2 were withdrawn? Para 2.1, that is amount realized. The meaning of amount realized, the clarification was given with respect to that. That has been withdrawn. And second is para 2.5, that is the period of calculation of fees. And both of these have been withdrawn. So basically what I'm trying to say is, firstly, a circular came on 28th September saying or giving the clarification that this has to be followed while calculating the liquidator's fees, liquidation fees. Then based on that, a lot of controversy happened because there were many liquidation cases going on and people had calculated it other way. Maybe they were not doing it according to the circular. So whatever excess they were charging, that excess had to be deposited to the IBBI. As per the circular, it was mentioned that if you do not deposit the excess amount of fees within this and this date, then disciplinary action will be taken on you. So that was clearly mentioned in the circular. I'll share the circular also. I think we should see the circular itself to understand it better. So the circular number 61. Just give me a moment. I'll just find out the circular and then let us read it with the circular. Anyone has any clue regarding that? Or it is new for everyone? Normally, when we see the cases, it is between 2 parties or the disciplinary committee case as we have seen. But here the case which we are discussing is against IBBI. One of the insolvency professional, Mr. Amit Gupta, he has filed a case against IBBI that he cannot issue such circular. And because of that particular case, another circular came up withdrawing the earlier provisions. So this is a very, very important case. Partial modification, 28th September, I have to do. Just give me a moment, I'll open that up. Okay, so this is the circular. I hope it is visible.
Yes.
Okay, so you can see circular number 61. On 28th September, the circular was issued. What does it say? The subject is clarification with respect to liquidators' fees under clause B of Regulation 2 of Regulation 4 of IBBI liquidation process regulations 2016. So basically, it is dealing with it is giving clarification. It is not giving some new thing. It is just clarifying whatever was mentioned in the regulation because there was some confusion. So they thought to give a clarification for those. So this is only a clarificatory circular with respect to the calculation of the liquidator's fees. So here it is saying what all things have changed. So this is the first point, amount realized. So let us just read it from here. Regulation 42B provides that the fees shall be as a percentage of the amount realized net of other liquidation cost and of the amount distributed for the balance period of liquidation dash dash. So here the word amount realized is clarified. So here they are saying that amount realized means an amount that is being realized from the sale of an asset where the asset changes form. Where the asset is already in liquid form, such as cash and bank balance, including term deposit, mutual funds, and quoted shares, there is no realization. And funds are readily available for distribution. The amount realized thus implies the proceeds from the sale or realization from the liquidation of the assets which are not liquid. Therefore, the liquidator is not entitled to a fees on realization of these liquid assets and is entitled to a fees only on the distribution. What is the clarification? Clarification says that amount realized shall mean amount realized from the assets other than the liquid assets such as cash and bank balance, including term deposit, mutual fund, quoted shares available on the start of the process after exploring compromise and arrangement, if any. So what was happening, maybe some of you are maybe doing it in a correct fashion, but since the clarification is there, it is assumed that majority of the people were not doing it in a current way. Suppose in the case of liquidation, the value of liquidation at the time of liquidating the assets, the calculation of the fees should be based on the amount realized, how much you could realize, or as a percentage of that you have to take care into. So here the IBBI is of the view that you should classify the assets in two categories. One is the liquid assets, the other is which are not liquid. So the assets which are in liquid form already, there you are not paying, and you are not doing any effort to realize them. They are already in the liquid form. Maybe they are, which we can say they are in quick liquid form. They are easily marketable, the cash and bank balance. So on that particular, you should not charge any fees. Fees can be charged only and only on the assets which are not in liquid form, like plant and machinery or the building or anything like that. So if you are realizing those assets which are not in liquid form, that percentage on that only can be calculated as a liquidation fee. But it might be the scenario that people were charging fees on the overall amount realized, including the cash and bank balance also. Whatever the amount was realized, on the whole amount, the percentage was charged as a fees. So according to this circular, whatever extra you have charged, so this is mentioned here at the end. The IPs, this third point, the IPs who are currently handling or have handled in the past any liquidation assignment shall ensure that the fees charged by them under Regulation 42B is in accordance with the above clarification and inform the same to the board electronically on the website of IBBI. In case where excess liquidators' fees is returned and distributed on or before 31st October 2023, no disciplinary proceedings will be initiated on the ground that the excess fees was charged and has now been returned. So this is the point. This was the point of controversy. If people have already charged the fees, they have already got the amount based on their own calculation. They have not calculated it according to this clarificatory circular. Then whatever the excess was charged by them, that had to be deposited with the IBBI, or else IBBI will take a disciplinary action on them. And the fee and the date was also mentioned here. Till 31st October 2023, they had to refund the amount. And believe it or not, people had refunded in crores. The total amount, it is mentioned in the order how much they have refunded to the IBBI. Just after reading this particular circular, people have deposited the excess fees. But one of the IPs, Mr. Amit Gupta, took the courage and he filed a case against IBBI saying that you cannot issue such kind of circular threatening the IPs that if we do not deposit the excess fee, you will initiate the disciplinary proceedings. So this is what the background of our case. So this is 2.1. This has been withdrawn now. So this is a major judgment. I could say that this 2.1, where they were saying that amount realized will mean this, but this particular thing has been withdrawn now. And again, 2.5, let me walk you through 2.5 also. This is 2.5, period of calculation of fees. Let us read it from here. It has been observed that liquidators are suo motu excluding various time periods such as stay by court on sale of a particular asset, delay in relinquishment by the secured creditor for the purpose of calculating the fee. However, since the liquidator works under the overall guidance of the adjudicating authority, Any such exclusion should have stamp of judicial authority and should be only for the asset for which such exclusion has been granted. So what is the clarification? Exclusion for the purpose of fees calculation is to be allowed only when the same has been explicitly provided by the Honorable NCLT or NCLAT or any other court of law and will operate only for that particular asset which could not have been realized during the excluded period. So two things have been withdrawn. 2.1 amount realized part that has been withdrawn, and this period of calculation of fees, whatever clarification is given with respect to this has been withdrawn. Rest of the circular still holds good. So this is the background of that particular case. Now let me take you back to the case law. Can you see the presentation now?
No, ma'am, no.
Okay, then I'll have to
Still
stop and
circular is there.
okay, I'll have to stop and share again. Is
Yes.
it visible now? Okay.
It is circular bill 70.
Yeah, this is the part of presentation, sir. So this is what we are discussing, that this was the earlier circular. This has been overruled by a new circular, and few changes have been made, modifications have been made. This we have already discussed. This was given in the circular. So now we are directly coming to the case. This case is Amit Gupta versus IBBI. You will not find these cases often because normally people do not file case against the authority or the institute. But here Amit Gupta ji has filed a case against IBBI, and this is a Bombay High Court judgment, a very recent judgment, 4th April 2024. What are the facts of the case? The IBBI issued to the petitioner a show cause notice. So here petitioner is Mr. Amit Gupta. IBBI issued a notice to him on 14th March. This is the first show cause notice alleging that the petitioner had charged excessive fees in the course of liquidating a company by the name Hindustan Door Oliver Limited. The petitioner replied to the first show cause notice on 3rd April 2023 and attended a personal hearing on 11th April 2023. A disciplinary committee of the IBBI did not pass a final order on the first show cause notice, but instead the IBBI directed that a wider inspection of the petitioner's assignment be conducted. Why these dates are important? Because this show cause notice was issued much before the circular. Circular came in September. The first circular that came in September 2023. So before that, this proceeding was going on against him. First show cause notice was given, and he has also given his part of submission. Then disciplinary committee did not finalize or settle the case. They simply asked to further investigate the case. So the case was still on. Meanwhile, the circular came in. So this is how the case is developing. Accordingly, on 22nd May 2023, the IBBI issued a notice to the petitioner communicating its decision to inspect certain liquidation assignments handled by the petitioner and directed him to submit various documents in connection with such assignments. After inspection, a draft inspection report dated 27 July came to be served upon the petitioner seeking his comments. The petitioner provided an issue-wise response on 4th September 2023. This is again the date, again and again you have to check the date because this is well before the circular date. The petitioner provided an issue-wise response on 4th September and a final inspection report dated 15th September 2023 was prepared by IBBI. Thereafter, on 28th September 2023, the IBBI issued the impugned circular invoking Section 196 of the IBC purporting to clarify the interpretation of the terms amount realized, other liquidation cost, and amount distributed to stakeholders as used in Regulation 42B of the Liquidation Proceedings Regulations. The impugned circular also purported to clarify how the time periods applicable for computing fees towards realization and distribution should be computed under the regulation 42B. So now you are understanding what is happening. Already the inspection investigation had taken place. The report was also prepared. Meanwhile, this circular came in and they provided a different method of calculation and the time period also they have mentioned which period to be included, which period not to be included, and how it is to be computed and everything. So again, they are reopening the case and they are checking it in line with the circular. So that is where this is being challenged. After the final inspection report and based on its findings, the IBBI issued to petitioner another show cause notice dated 4th December 2023. This is the second show cause notice. The second show cause notice found fault with 8 liquidation assignments handled by the petitioner. Although the impugned circular was issued after the final inspection report and the actions of the petitioner assailed in it occurred prior to the issuance of the impugned circular, the second show cause notice relied on the impugned circular to interpret regulation 42B of the LP regulations. So finally, what the crux of this para is simply that the report basically highlighted that you have not followed the guidelines given in the circular. Though that was issued much later, but still they are saying that you have not followed the circular. So what are the allegations mentioned in show cause notice? So this is very, very important to understand what were the basic allegations put on that particular insolvency professional. First is excess fee charged in liquidation assignments handled in the case of 8 liquidation assignments handled by the petitioner, including the liquidation of HDOL. Reduction in reserve price during liquidation in the case of Padmavati buyers. C, that is the third allegation, sale of stock without auction in case of Nimitz Steel and Alloys Private Limited. And the fourth allegation was engagement of one Anarock Capital Advisors Private Limited for assistance in the sale of assets in the case of HDOL. So let me know it from you all whether and or in any case, if these are the charges or these are the allegations, how will you reply for this? Are these valid allegations? Excess fees charged, first is this. Second is reduction in the reserve price during liquidation. Third is sale of stock without auction. And the fourth is taking assistance in the sale of assets of any other person. What is your view regarding these allegations?
As far as B is concerned, it is allowed with the consent of committee.
Perfect, sir. Yes.
As far as C is concerned, this is all sales must be by auction.
Right.
That's all.
Okay. So basically, actually, when we read this complete judgment, there is nothing mentioned about these allegations. They have just mentioned that this was there in the show cause notice. However, the judgment does not comment anything on these allegations. We are continuing with the facts. The challenge in this writ petition is to circular dated 28 September 2023 issued by respondent 1, that is the IBBI, purporting to clarify the usage of certain terms contained in regulation so and so. The challenge is primarily on the ground that in the garb of this para is again very important because the language they have used is very important here. The challenge is primarily on the ground that in the garb of clarifying certain terms contained in regulation 42B, the IBBI has effectively, by a backdoor method, amended the LP regulations by stipulating new substantial requirements, and that too with retrospective effect. So this is the this thing is being challenged here, that IBBI is using a kind of backdoor method. They have not done it, as per the regulations. Whenever they have to be amended, a proper procedure is there. It has to be passed in the houses, and then it is made a law. That way, it is done. So it is not. They have directly done it through a circular. So whether it is allowed or not, that is a question here. So in the garb of clarifying, just to say that we are just clarifying, they have introduced the things, they have introduced new things, and that too with retrospective effect. And that was being challenged in this particular case. What is the impact? This is the impact which I was talking about. In 111 cases, liquidators have realized their mistake after reading the impugned circular and have refunded excess fees to the tune of 5.75 crores, while 630 liquidators have confirmed that their understanding was consistent with the IBBI's interpretation of Regulation 42P. So what is the issue arising? Whether the circular is ultra vires the liquidation proceeding regulations, liquidation process regulations. Whether it is an instrument that illegally amends the LP regulations. So what is the observation of the High Court? IBBI's explicit intention is that IPs who are currently handling or having handled liquidation assignments must adhere to the positions stipulated in the impugned circular. That was mentioned in the circular. This would extend even to the past assignments already handled by them, where the interpretation stipulated in the impugned circular leads to a conclusion that excess fees have been charged. Such excess fee is required to be returned and distributed on or before 31st October 2023, failing which the wrath of disciplinary proceedings would be attracted. It is vital to examine if the impugned circular is merely clarificatory or if it introduces new standards. If it were purely clarificatory, it would only explain how Regulation 42B ought to have always been understood. So if clarification is there, that part is okay. However, if it were to stipulate new legal standards, it would be a backdoor amendment of the LP regulations without following the process of law, and that too retrospectively. So here HC, in detail, they observed whether it was merely a clarification or it was named clarification. However, it was not so. It was a kind of amendment to the LP regulations. So that is what they have discussed in detail. Should the IBBI be desirous of amending the LP regulations, it would have to comply with the law-making regulations and not resort to backdoor route of issuing circulars. On the other hand, should the IBBI be desirous of issuing only clarificatory guidelines, it is free to do so in terms of Section 196(1)(t). Using the term liquid as an adjective for an asset in the context of liquidation can at best be a wordplay. If it had been the intention of the earlier either Parliament or the IBBI to make such distributions, such a classification would have been found in the provisions of these legislations. Such classification is introduced for the first time in the impugned circular without any backing in the legislation. So this classification was introduced for the first time and there was no backing for that. There was no support why they are doing so. Therefore, to inflict the wrath of disciplinary proceedings, be it penal or remedial in nature, by introducing para 2.1 of the impugned circular in the midst of the ongoing regulatory proceedings without any backing for it either in the IBC or the LP regulation is manifestly arbitrary and unconstitutional. We have no hesitation in striking down para 2.1 of the impugned circular as being ultra vires the IBC and LP regulations. And therefore, by this particular judgment, finally, we can see a new circular was issued by IBBI saying that 2.1 and 2.5, those two particular paragraphs will be withdrawn. Final order, para 2.1 and 2.5 of the impugned circular are hereby struck down as being ultra vires and the LP regulations and the IBC. They introduce substantive amendments to statutory legislation even while purporting to be mere clarification. The changes they seek to bring in are not even covered by the IBC and the LP regulations. Due process by way of compliance with statutory requirements of the law-making regulation is missing. Therefore, in the course of conducting the quasi-judicial proceedings, the IBBI is prohibited from placing any reliance on para 2.1 and 2.5 of the impugned circular in determining if any fee charged by the petitioner in the liquidation assignments in question was in excess of permissible thresholds. So the order is not till here only. One more thing has been emphasized by the High Court here. So the emphasis is placed on this particular point. it is I have taken the as it is language here, what they have mentioned in the order. We would be remiss if we did not highlight to the IBBI that it must examine the serious effect of the issuance of a show cause notice to any IP. The very issuance of the show cause notice has the effect of stopping the IP from taking up new work. This is what I was talking in the beginning, that as soon as this show cause notice is given, it holds the insolvency professional to take up any new work. By the reason of bylaw 23A in the model bylaws that are statutorily specified in the schedule to the Insolvency and Bankruptcy Board of India, which provides as follows: the authorization for assignment shall stand suspended upon initiation of any disciplinary proceedings, because the term here is upon the initiation of the disciplinary proceedings. It is not that conclusion or whatever the final verdict is there. It is not based on that. As soon as the disciplinary proceedings are initiated, it will come to an halt. So that is where the emphasis is levied by the High Court also. They are emphasizing this point again and again, saying that this point should be, discussed further, and IBBI should come up with some remedial action for this. While the aforesaid provision is not under challenge before us, because this is not the point highlighted for the High Court to give any judgment, they are just emphasizing it and highlighting it for the IBBI to take care. We take judicial notice of the serious repercussions on the IPs when the IBBI issues a show cause notice. The moment disciplinary proceedings are initiated, the IP's authorization to conduct his assignments stands suspended. Such a position, enabled by subordinate law, can have serious implications for IPs. This position may also have the effect making the IBBI reticent to issue show cause notices, considering the debilitating impact it can have on any IP. This situation deserves to be reviewed by the IBBI. That is it. Though this particular point is highlighted many a times at many forums, but till now there is, no such thing in favor of IPs, which can, take care of our issues. There is no platform as such, though there are many authorities, we can always go up to them, but still it has not come in black and white that IPs can continue their work even if the disciplinary proceedings are there. I think I've finished off in time. Anything which you want to discuss or any comments from your side? Any feedback?
Thank you, ma'am. Wonderful session.
Please, sir. Thank you. I would like to be called Divya only, sir. You seem to be very senior to me.
Thank you.
Thank you, ma'am.
Thank you so
Thank you
much.
very much.
Thank you.
Very nice session. Hope to see you soon somewhere.
Thank you, sir. Thank you. Anyone from CS Institute? We can wind up the session. I think we can wind it up on our own.
I think a couple of us can drop off. Nobody from IIP, I think.
Okay. Okay. Thank you everyone for joining the session. Thank you so much.
Okay. Thank
Thank
you.
you. Thank you very much.
Bye. Bye.